Hi everyone, my name is John Tehranian. I'm a founding partner of the law firm 1 LLP. We have offices in Beverly Hills, Newport Beach, and Del Mar, California, and we specialize primarily in intellectual property and entertainment law matters. I'm also the Paul W. Wildman Chair and Professor of Law at Southwestern Law School in Los Angeles, California, where I teach, among other things, copyright law and intellectual property law and entertainment law. Today's topic is along those lines. The topic is entitled, Ain't No Monkey Business, Animal Selfies, Sex Tapes, and the Future of Authorship in Copyright Law. We're going to begin by talking about an event that many of you are familiar with. A couple of years ago, a crested macaque in the jungles of Indonesia came out with a photograph, a selfie of himself. This was the image that went viral across the internet, and many people immediately began to ask questions about the photo. How was it created? Did the macaque take the photograph himself? And what was the background? Well, the photo obviously is an intriguing shot. The macaque, if you look at his facial expression, appears to be aware that he is in fact being photographed and has a very human-like visage. The background to the photograph is as follows. A photographer named David Slater had spent a great deal of time in the jungles of Indonesia, several weeks in fact, working with the macaque and bringing his photographic equipment to them. At one point, a macaque took a selfie, this image that you see before you, and the image was captured as a result, according to Slater, of a great deal of work in terms of him setting up the shot, familiarizing the monkeys with the camera equipment, him focusing on lighting and angles. But there is one critical thing that Slater did not do in the taking this photograph, and that is he did not literally push the button. The button was pushed by the crested macaque in the photograph, hence it's a selfie. And the button was pushed by this individual, now known as Naruto. Naruto ended up suing Mr. Slater, the photographer or putative photographer, for copyright infringement when Mr. Slater started licensing this photograph to journalistic outfits around the country and around the world. The resulting lawsuit created more headlines, including headlines that said, "Monkey see, monkey sue," and resulted in a number of important questions that are fundamental to copyright law, and yet surprisingly to this day remain unanswered. The focus of our talk today are these questions. The question in particular of authorship. What does it mean to be an author? And how does copyright law basically allocate the rights under authorship? So we'll be using the macaque as an example to sort of get us into this conversation, and I'll be talking about the selfie case a little bit more later. In addition to the selfie case, we'll be talking about a number of other cases involving claims of authorship of a sort of racy manner. These are sex tape cases involving the recording of intimate footage, sometimes with the knowledge of the participants, sometimes without the knowledge of participants. And in a variety of these cases, including the Hulk Hogan versus Gawker lawsuit that involved a sex tape of Hulk Hogan with his best friend's wife, as well as the Erin Andrews case involving a lawsuit Erin Andrews brought to leaked video footage of her undressing in a hotel room. There were threshold issues of authorship and copyright law at play, and we'll be discussing those. Now, as a starting matter, when I talk about authorship, it's important to note that copyright law has a default rule regarding authorship, and that is, if someone is the author of a work, as a basic matter of copyright law, they own the copyright. The copyright vests with them. This is dictated by Article 1, Section 8, Clause 8 of the United States Constitution, the Copyright Clause, actually embedded in the Constitution, which says that Congress has the power to grant, for limited times, authors the rights to the respective writings. And so under the interpretation of this clause, we've always held that authors, as a default rule, are the owners of the copyright to material they create. Now, despite this fundamental rule, it might come as a surprise that there is very little definition in the law as to what it means to be an author, or how we're supposed to go about this process of determining authorship. In fact, the Copyright Act is full of definitions. We're told many things, like what it means to be a derivative work, or what it means to publicly display a work. We're even told what it means or even define terms such as children or a gross square footage. But strangely, the Copyright Act doesn't ever contain a definition of the word authorship, even though authorship is fundamental to copyright law and determines the basic vesting of rights. So if the Copyright Act doesn't help us, what other sources can we turn to? Well, the Constitution certainly doesn't tell us. It uses the term authors and implies that authors get a copyright, but it doesn't tell us how to determine who the author is. So we are left to look to the courts. And here the jurisprudence is surprisingly thin as well. Very little jurisprudence occurs or exists that really speaks to this fundamental nature of authorship. All this goes back to a case from 1989 decided by the Supreme Court called CCNV v. Reed. In that case, the court was pressed with the following question: who was the owner of a sculpture? Was it the commissioning party or the actual sculptor? Now, in the process of deciding this issue, the court gave us some guidance on the meaning of authorship. The court said as follows: as a general rule, the author is the party who actually creates the work. That is, the person who translates an idea into a fixed, tangible expression entitled to copyright protection. Of course, this definition begs two questions. First of all, where does the court get this idea that it is the fixer that generally gets the copyright law, that gets the copyright? And secondly, although the court posits this as a general rule, that begs the question: what are the exceptions to this general rule? Well, we're not really given good answers on either front. On the first principle, this idea of authorship as fixation, the court simply cites to one section of the Copyright Act, Section 102. But in fact, Section 102 makes no statement about authorship being an act of fixation. It simply says that copyright protection subsists in original works of authorship fixed in a tangible medium. In other words, Section 102 of the Copyright Act goes out of its way not to tell us who owns the copyright. It simply says that a copyright comes about when a work of authorship is fixed in a tangible medium. It doesn't say that the person who fixes the work is the one who gains the authorship. And of course, the second question: if there is a general rule of authorship as fixation, well, what other exceptions might there be to make that only a general rule? We're not told the answer to that either. Now, in the old days, for many hundreds of years, really, there was no question about authorship being synonymous with the act of fixation. After all, if one goes back to the original subject matter of copyright, which was basically just books and maps, the fixer was always the author. When you write something, you're also the fixer of that work, just as if you are someone who is making a map. You are the fixer of that work, so you're generally the author. So in other words, in the old days, there was a complete convergence of fixation and authorship. However, all of that began to change with the growth of the visual arts and the expansion of copyright law into a number of arts that were performative in nature. These types of arts, for example, photographs, sound recordings, acting, movies, all involved numerous creative contributions, and the creative contributions in forming these works came not just from the person literally clicking the camera, but sometimes from people who were behind the scenes, for example, the makeup artist or the staging director, or in fact from people in front of the camera, the actress, the subject, the recording artist themselves. So there became a disjuncture between artistic effort, which was coming from multiple sources, and fixation, which of course occurred only from one person, the person behind the camera. Now, obviously, this created a problem. And the problem was exacerbated further by the advent of technologies that allowed for the creation of amateur content. In the old days, the authorship fixation divergence was solved by the fact that major companies were the only ones who were producing exploitable commercial copyrighted content. Hollywood studios, record labels, professional photography studios. As a result, these entities were sure to, of course, get contracts in place that would make it a non-issue as to who authored the works. So, for example, if you were an actor, you would sign a contract with the motion picture studio you were doing a movie for. And that would basically make clear that the motion picture studio owned all of whatever contributions you made to that motion picture as a work made for hire. Similarly, if you were someone who was being recorded, you would sign away your rights by contract to basically make clear that the recording company, the people who owned the recording equipment, would own the rights. So sound engineers, record producers, and performers themselves might contract away any copyrights they had to the record label. And subjects in photos would contract away rights that they had in the photographs by giving those rights to the photographer. However, with the advent of the 21st century, the explosion of amateur content, and the growth of websites such as YouTube and other viable means for people to exploit amateur content for commercial gain, a lot of content is now valuable in the marketplace, and that has not been created in a professional manner. This content oftentimes comes with actors or performers or subjects who have never signed a contract. And so the question of who the author of the final work is becomes live. It is not anymore settled by contract. In a world of Tumblr, Facebook, Vine, Snapchat, Twitter, and Instagram, where creative works are being constantly propagated through the internet, where commercial value is being derived from these creative works, and where the creative works do not have any underlying contracts attached to them to resolve the issue of authorship, authorship has now come to the forefront of copyright law. And so we're beginning to see a series of challenges to copyright law and its authorship doctrine. We certainly saw it with the case of Naruto, the crested macaque from Indonesia, but we've also seen it in a number of other cases. A case we'll be talking about involving Cindy Lee Garcia, an actress who unwittingly found herself receiving death threats after being featured in a movie called The Innocence of Muslims. We found it come up in the case of Hulk Hogan and his sex tape lawsuit against Gawker. Erin Andrews, the famous sports reporter, in her litigation against the Peeping Tom that posted voyeuristic footage of her undressing in her hotel room. Now, we're going to combine these cases to come up with a sense of where we have come up with the notion of authorship as fixation. We're going to look at the historical roots of this trope, and we're going to talk about some of the specific problems with this default rule of authorship as fixation, and discuss ways in which courts may want to be more open to the notion of creative contributions coming from those both in front of the camera and those behind the camera who didn't necessarily click the magic button. We're going to begin first by looking at a major case that brought the issue of authorship and authorship as fixation to the forefront of copyright jurisprudence a couple of years ago. This case is called Garcia v. Google. Garcia is Cindy Lee Garcia. She was a struggling actress who, several years ago, was hired to perform in a movie. She agreed to perform in the movie, and the movie, she thought, was a swashbuckling Arabian Nights type of adventure set in the desert. So she showed up, she performed her role, and she thought everything was fine. Well, shortly after performing her role, she began to receive death threats. Unsure as to where these death threats were coming from, she was referred to YouTube, where she found a trailer to her movie. But much to her horror, the movie was not a swashbuckling Arabian Nights type adventure story set in the desert. Rather, it was a movie that had been charged with being Islamophobic, one that had been renamed The Innocence of Muslims. And Cindy Lee Garcia, much to her horror, found that her lines in the movie had been overdubbed with specific attacks on the Prophet Muhammad, including allegations that Muhammad was a child molester. Not surprisingly, Cindy Lee Garcia then started receiving these death threats because people thought that she had been saying the lines and that they were not overdubbed. Terrified, she turned to legal counsel to try to do something about this perilous state of affairs. What did she do? Well, she looked to get the tape removed from YouTube. The easiest way to get content removed from YouTube, and arguably one of the only ways, is to make a colorable copyright claim. To claim that, in fact, you have a copyright interest in the work that is being displayed on YouTube and that it was placed on there without your permission. And so that's just what Cindy Lee Garcia did. She claimed that as a performer, she had provided creative contributions, original contributions, to a work of authorship, the movie, that was fixed in a tangible medium, and that therefore she owned a copyright interest in the work, and that the work had been placed on YouTube without her permission, therefore infringing her rights. She demanded YouTube take the video down. YouTube declined. They claimed this would be a form of censorship, and they challenged whether she was the author at all. After all, it's long been the practice in Hollywood and the motion picture industry to view the de facto author as either the director of a work or, in fact, the producing company that signs work-made-for-hire agreements with everyone. Importantly, though, there was no work-made-for-hire agreement with Cindy Lee Garcia, so she had not contracted her rights away. And so she sued. She lost at the district court level, but in what became a very famous opinion by the Ninth Circuit, United States Court of Appeals for the Ninth Circuit, in an opinion written by Judge Kaczynski, she was granted a victory. Judge Kaczynski effectively held that Cindy Lee Garcia had, in fact, authored a creative work and that it was fixed in a tangible medium, and that there was no basis to claim that she had no copyright interest because she had not given away any interest by license or by the work-made-for-hire doctrine. Therefore, she had standing to sue for copyright infringement. And the court said, in light of the grave threats to her health and her well-being, there was strong interest to grant a preliminary injunction to enjoin the video being placed on YouTube. YouTube was ordered to immediately take down the video. YouTube challenged the holding, however, and petitioned for an en banc rehearing, which was granted. And in a stunning moment of a conflation of interests between two groups who have been fighting for years over copyright law, Silicon Valley on one hand, and the Motion Picture Association on the other hand, the two groups came together and vigorously decried the Garcia v. Google ruling by Judge Kaczynski. Silicon Valley, of course, has long questioned whether our copyright laws are too stringent, in the sense that they place potential liability on internet service providers like Google for infringing activity that arguably they should not be held responsible for. Meanwhile, the Motion Picture Association of America has been concerned for years about the growth of digital piracy and the ability of the internet to allow piracy that has never been before seen. And so they have pressed for actually greater liability on internet service providers and for an expansion of rights for copyright holders. In other words, Silicon Valley and Motion Picture Association of America have rarely agreed on copyright matters, and yet in this instance, they agreed. Hollywood, of course, was concerned that by granting a performer a copyright interest, this would open up the floodgates for a lack of control over who an author might be in the creation of motion pictures. In other words, Hollywood was concerned that actors and actresses of all stripes would now begin to press copyright claims, as well as other individuals, makeup artists, the assistant key grip, and others involved in motion picture creation, claiming that they had added creative contributions as well. This kind of scenario, Hollywood argued, would lead to the balkanization of authorial rights and create a major cloud over the title of its intellectual property interests, thereby adversely impacting licensing and the fundamental interests of the studios. At the same time, Silicon Valley was concerned, because if in fact, a multiplicity of authorial interests could exist, as the case of Cindy Lee Garcia suggested, suddenly Silicon Valley would be receiving takedown notices from all sorts of individuals, takedown notices that would effectively remove content from internet services such as Google, such as YouTube, and in fact undermine the free speech rights of these entities as well as their basic business interests. Now, the amount of heat the Kaczynski opinion received in the general press as well as from copyright commentators was nothing short of stunning. There was almost universal disdain for the case. I'll give you a few quotations. The opinion was roundly and widely condemned as, quote, truly awful, as, quote, butchering copyright law, as, quote, wrong on the law, terrible for Hollywood, even worse for the internet, and doesn't even make things right for the poor actress, and as, quote, incredibly troubling. In short, this was a decision that was almost universally condemned and hated. Yet, as we'll posit in this CLE, although there were certainly troubling aspects of the decision, including the short shrift it gave to the First Amendment interests to YouTube and the other speakers, as well as its myopic view on some of the key issues involving copyright law, the decision actually raised some important points that were lost in the race to condemn its outcome. Specifically, its questioning of this notion that the author must always be the fixer. And that's something we're going to be looking at. Now, certainly, Kaczynski's opinion in favor of Garcia seemed troubling and problematic, as I mentioned, on First Amendment grounds, because it didn't consider or didn't give much consideration or weight to the rights of internet service providers and the rights of others speaking to engage in their speech without effectively being given a prior restraint from a court, effectively banning speech or subjecting it to contempt. However, the case also had other problems. The court Kaczynski's decision suggested that the situation involving Garcia was exceedingly rare because usually, the court posited, this situation would never come up because ordinarily people have contracts in place. Either that or the license or implied license doctrine would take care of the problems that Cindy Lee Garcia had raised here. However, neither of those two excuses are particularly compelling. First of all, in terms of contracts, the reality is the explosion of amateur content has made it profitable now to exploit works where people maybe do not have huge upfront budgets, where they don't have counsel in place, and therefore, in fact, don't get proper work made for hire contracts put into place by all the individuals working on a set, including the performers. As a result, we're increasingly likely to see commercially viable content where, in fact, there hasn't been a team of contractual provisions put into place to eliminate authorial questions. Secondly, the work made for hire doctrine has actually gotten more difficult for commissioning parties post the 1976 Copyright Act. In the old days, a party that had a work created at their instance and expense was generally held to be the copyright holder, and the works of all contributors were considered to be works made for hire. However, under the 1976 Copyright Act, there are only two ways to get a work made for hire. Either you have to pretty much be a technical W-2 employee working in the context of your employment to have the copyright go immediately to your employer, or if you're an independent contractor, you have to have a specially commissioned work in writing document put into place. Well, again, as we've argued, increasing growth of amateur content means there are going to be fewer and fewer instances where all of the contracts are in fact in writing and properly done under the special commission requirements of the Copyright Act. As a result, we're increasingly likely to see scenarios like Cindy Lee Garcia, where an actor or actress has not properly signed work made for hire agreements, and therefore there is a colorable copyright claim to come from the actor or actress or someone else who was working on the set. Secondly, the idea that the implied license doctrine can take care of this problem is also problematic. Of course, the court said there was no implied license in this case because Cindy Lee Garcia believed she was shooting a movie about a desert adventure. She did not believe she was shooting a movie that was an attack on Islam. As a result, the court said she did not impliedly give a license for the use of her creative work in this work because of the deception that had been done by the producers of the movie. However, there are many, many works that are copyrightable where they are commercially viable, where in fact the people on camera did not give permission also for the recording. Yet we wouldn't necessarily want them to have copyright interests. Think about several recent controversies involving filmed footage where a significant news story was brought to the forefront of the headlines. I'll give you a few examples. First, a few years ago, Baltimore Ravens running back Ray Rice, video footage of him in an elevator beating his then fiancée. That footage was critically important to questioning the domestic violence policy of the NFL, and that footage was seen as de facto proof of the fact that something terrible had happened involving Ray Rice and his fiancée. The broadcast of that footage is something that should be disseminated and should not necessarily be held up by copyright law because of its importance on an issue of significant political and social concern. Yet, if we were to give copyright interests to performers, Ray Rice could argue that he was a performer in that footage and that he didn't give an implied license for the use of his image in the elevator, and that therefore he can enjoin that footage from being distributed over the internet, much like Cindy Lee Garcia did. Similarly, we had footage a few years ago of Mayor Tom Ford of Toronto smoking crack despite his claims that he had never done so. Again, performer copyrights could arguably give him the power to enjoin that footage and suppress it so that the news media wouldn't be able to report on that issue. Or consider what happened during the Summer Olympics a couple of years ago with Ryan Lochte and the whole issue about what happened to Mr. Lochte after he and his teammates had returned to the Olympic Village in Rio after a night of allegedly being robbed at gunpoint. Footage that showed, in fact, that they had been lying. Again, all of these issues raise the fact that there are many types of instances where copyrighted works will be created without the permission or implied license of the performer, and yet it would be dangerous to necessarily just say that the implied license doctrine can take care of the issue of copyright ownership. Now, that said, the Google v. Garcia decision, despite the fact that it has been so resoundingly criticized, actually does have strong merit. And that merit is in its challenge of this idea that authorship must necessarily go to the fixer. The en banc decision by the Ninth Circuit resoundingly defeated the Kaczynski view. And in the decision, the Ninth Circuit effectively made it the law of the circuit now that whoever fixes a work of authorship in a tangible medium, they are the copyright holder. And as a result, the court said Cindy Lee Garcia could not possibly have a copyright interest. However, this idea as the author as fixer is deeply problematic because in many cases, there are individuals that provide important creative contributions to copyrighted works and may have legitimate claims to interest in those copyrighted works, even though they didn't fix the work in a tangible medium. Consider an example of a lecture. I'll give a particular example involving the lecture of a professor, a law professor, for example. Law professor lectures in class. Students take notes. Let's say that a student company comes about where students come to class, take notes, and then sell those notes, therefore making commercial exploitation of the lectures. Okay? Let's go back to the authorship as fixation rule. If the professor lectures and never writes down his lecture and the lecture is not recorded, under the authorship as fixation rules and under the rules of copyright, which say that you can't get a copyright in a work unless it is fixed in a tangible medium, there is no copyright to the lectures for the professor. Yet the students are writing down the lecture notes. Arguably, under the authorship as fixation rules, the students, by interpolating the lecture and writing it down, in fact, do have a copyright interest in their notes. With that regime in mind, if one were to spin this example out all the way and say that authorship as fixation would give the students, therefore, the copyright effectively to the notes in the lecture, they can then sell these notes and engage in commercial exploitation of labor that arguably is chiefly the professor's. In other words, in this scenario, the authorship as fixation doctrine wholly ignores the creative contributions of the professor who actually gave the original lecture, and in fact allows the students to exploit the value of that lecture without any interference from the professor. Now, this is not just a singular example. After all, we can think of examples involving any manner of performative work, where arguably the fixer, by simply getting a copyright interest, will be able to free ride off of the labors, including the creative labors, of those who perform. This could happen, for example, in a case involving an interview, where the interviewer provides substantial creative contribution but gets no copyright interest in it because it is fixed by someone else. This could happen in the case of, say, a performer, a musician who performs, but yet the video is bootlegged, and therefore the bootlegger gets the copyright. Or a skateboarder performs a trick, but really the copyright holder is the person in front of the camera. Any myriad number of examples give rise to these issues. And in fact, we've seen these issues come up in a series of cases involving interviews. I'll give you two in particular that raise troubling questions as to how courts are treating authorship as fixation and badly mangling copyright law in the process. The first case, Taggart v. WMAQ, Channel 5, involved a rather misguided news interview. There was an individual who had been accused of aggravated criminal sexual assault of two boys at a summer camp. He claimed he was innocent and as a result sat for an interview with the news media. In the course of his interview with the news media, he admitted that naked boys would regularly share his sleeping bag, and then he protested the interviewer's characterization of his activities as molestation. When asked how he would put it, he responded, quote, "learning experience." Obviously, this interview did no favors to the criminal, and the criminal quickly moved to suppress this video from going public. What did he do to do so? He claimed a copyright interest. The case went to the courts, and in an issued published decision, the court rejected his argument and said that Mr. Taggart could not possibly have a copyright interest. The court held that courts have not and cannot recognize a proprietary interest where there is no tangible embodiment of the expression of an idea. In other words, the court said, quote, "the utterances made during an interview are not an expression of an idea for the purposes of copyright law. They are simply an idea and thus not subject to copyright protection. Affording such protection would make each vocalization a piece of property that is afforded the formidable protection of copyright law. Furthermore, affording such protection of materials gathered in the daily task of news reporting would essentially bring the industry to a halt." Now, I'll contend, although the court may have been ultimately correct in denying Mr. Taggart's claim, its logic was deeply faulty. After all, for those of you familiar with copyright law, the threshold for copyrightability is incredibly low. The originality doctrine suggests that in copyright, you merely need to have a mere modicum of originality to get copyright protection in something. So the court's idea that excited utterances could not be copyrightable seems far-fetched. In fact, if one looks to the vast jurisprudence on copyright originality, we'll see copyrightability being given to the acts of creation that have very de minimis originality. For example, a furniture wax label that merely lauds the product and instructs its use has received copyright protection. Star pagination, the use of a little asterisk in legal opinions, has received copyright protection. Phrases such as meter drop or rolling stock have received copyright protection. Used car valuations have received copyright protection. So it seems quite wrong to declare that what an interviewee might say, a series of phrases in fact, could lack copyright originality. Instead, the court could have dispensed of this case by saying that Mr. Taggart, although he might have a copyright interest in his utterances, gave an implied license by sitting for the interview, an interview he knew was going to be broadcast. And therefore, although he had a copyright interest, he had effectively given a non-exclusive license to the television studio to run the video. The court did not go in that direction. Same thing happened in another case involving the Reverend Jerry Falwell, who once sat for an interview with a magazine that he later ended up finding out was pornographic in nature. The Reverend was terribly upset by this, did not want to be seen as condoning pornography, and therefore sought to enjoin publication of his interview. He therefore used copyright law as his tool to do so. And the court similarly rejected his claim, again on the grounds that it lacked originality. Now, again, here the court could have simply found implied license. The court wrote, however, the plaintiff cannot seriously contend that each of his responses in the published interview setting forth his ideas and opinions is a product of his intellectual labors that should be recognized as a literary or even intellectual creation. That seems wildly inconsistent with the idea of star pagination, used car valuations, and instruction manuals for basic products being subject to copyright protection. Now, we can understand why the courts reached their ultimate conclusion on the interview cases, but their logic was faulty. The courts failed to consider the possibility that something other than the putative author's failure to personally fixate the work in question may have doomed the infringement claims. But instead, they relied on the authorship as fixation doctrine, and in the process betrayed basic copyright principles on originality. Now, as we can see from the interview cases, courts have gone through all kinds of machinations to avoid granting copyright interests to performers in front of the camera who were not involved in the direct fixation of the work. These machinations are troubling, in particular with the growth of a number of technologies, including surveillance technology. Let me give an example. That is the recent Hulk Hogan case against Gawker. As you'll recall, a couple of years ago, Hulk Hogan famously sued Gawker under his birth name, Terry Bollea. Gawker, of course, was a news media site that had run footage of him having sex with his best friend's wife, Heather Clem, who was the wife of Bubba the Love Sponge, Hulk's putative best friend. Apparently, the footage was recorded on a surveillance camera in Bubba the Love Sponge's bedroom. Now, Hulk Hogan initially claimed that the lawsuit not just violated his privacy, but also infringed his copyrights. Yet, for him to be able to claim a copyright interest in the final work, he actually had to go through a series of bizarre legal maneuvers. Specifically, the authorship as fixation doctrine, oddly enough, would hold that it was the fixer of the footage that owns the copyright interest in the footage. Not necessarily the people in front of the camera, not necessarily Heather Clem, not necessarily Hulk Hogan. As a result, as a default rule of copyright law, perversely, it was Bubba the Love Sponge who had put a surveillance camera in that room who owned the copyright. Now think about the consequences of this from the point of view of basic copyright principles. Copyright is usually a doctrine that is meant to reward creativity. And it is seen as a reward of creativity that gives kind of certain economic benefits. Yet, who was the creative party here? Now, I don't want you to speculate too heavily, and I'm certainly not telling you to watch the video. But let's just think about the various creative contributions of the participants in this movie on a general level without getting into the actual details too much. There was the supposed author, Bubba the Love Sponge. What was his creative act? Nothing. He set up surveillance footage, and that was it. The camera ran. And then there was Heather Clem, and there was Hulk Hogan. Now, no matter what you may think of their sexual techniques, their comments during the sex, or anything else that happened, they certainly contributed more creative content to this video than Bubba the Love Sponge did by simply setting up the camera. And yet, the authorship as fixation doctrine gave Bubba the copyright, not Heather and not Hulk Hogan. So in order to actually sue to get the footage taken down under copyright law, Hulk Hogan had to actually make a deal with Bubba to, in fact, get an assignment of the copyright. Now, although there are plenty of reasons in that case not to feel too sympathetic for Hulk, including the fact that he allegedly knew that he was being recorded, thereby making the case and his claims of invasion of privacy far more dubious, information that was in fact withheld from the jury when it ultimately returned a verdict in his favor. Consider a case that's far more sympathetic to the person on the camera who was unwittingly recorded. For this, we turn our attention to the case of Erin Andrews. As you know, several years ago, sports reporter Erin Andrews was illegally filmed in a hotel room by a peeping Tom. An individual who had been stalking her found out which hotel room she was staying in, got the hotel room next to it, created a peephole between his hotel room and her hotel room, and then using a microscopic camera, filmed footage of her undressing. He then leaked this footage onto the internet. Erin Andrews, of course, was livid. Her testimony, when she ultimately sued him and the hotel chain, was compelling, as she recognized the internet lasts forever, and once video is on the internet, no matter what you do, it's impossible to remove. She was tormented by this footage, and she says not a day passes where she becomes upset again by the idea that individuals through a simple Google search can go online and just see her naked in her most intimate moments. Now, what could she do about this? Well, one tool she has is copyright law, as we've seen. However, Erin Andrews wasn't the copyright holder to this footage. Who was? Under the authorship as fixation doctrine, perversely, it is the peeper, the individual who illegally sawed a peephole into her room, that actually fixed that footage in a tangible medium. He therefore owns the copyright. So in order for Erin Andrews to actually prevent this videotape from being disseminated all over the world online, she actually had to acquire the copyright from her tormentor, register it with the Copyright Office, and then proceed to actually engage in possible takedown notifications to remove the footage online. Needless to say, the idea of putting this in the hands of Erin Andrews and having her, after being subjected to this terrible action, have to negotiate with her tormentor to obtain a license to copyrighted footage of her herself in such an instance seems appalling, inequitable, and certainly seems to defeat any goal of the copyright regime. Putting that aside also, one must also ask what this says about the authorship as fixation doctrine and how it talks about the potentially devastating consequences of the doctrine, not just from the point of view of its failure to acknowledge the creative interests of performers in front of the camera, performers who might be the musician giving a performance, a lecturer giving a speech, a skateboarder doing a fantastic new trick, or other individuals who are in the creative arts, but also its implication issues of surveillance footage, as demonstrated by the Hulk Hogan case and the Erin Andrews case, where literally the individual in front of the camera effectively has no say. This issue has come up also in the context of revenge porn. Revenge porn, of course, is the practice that unfortunately has exploded in recent years of jilted lovers taking footage they had taken of former lovers and placing it online in an effort to embarrass or humiliate them. Revenge porn, unfortunately, has a distinctively gender-based dynamic. Although not always, it is oftentimes an angry boyfriend using footage of an angry of a girlfriend and placing it online without her permission. What happens in these scenarios is obviously devastating to the performers in front of the camera. Their footage, whether taken sometimes without even their permission, or taken with their permission but under the understanding that it would be kept confidential, is now out there for the world to see. Suddenly, an individual who was sharing intimacy with a former loved one is now basically a tool of pornography on the internet. And their efforts to be able to fight the phenomenon of revenge porn are highly limited because until recently, revenge porn was not illegal. There are also questions as to whether even the recent spout of revenge porn laws have been constitutional and whether they will survive First Amendment scrutiny, something that hasn't actually been decided yet. The main tool that these individuals have left at their disposal is copyright law. And it is a powerful tool because it can cause the forcible takedown of infringing materials from online networks, and it can subject infringers to tremendous penalties. But these tools of copyright law are limited only to a copyright holder. And what does authorship as fixation tell us? It tells us that it is the fixer who owns the copyright. And in the law of the circuit, the Ninth Circuit, that means it is not the individual in front of the camera who did not literally click the camera. So it could be the teenage girl who unwittingly is convinced by her boyfriend to tape a sexual act, who then finds herself floating around the internet. Since she was not the fixer of the work, she has no ability to take down the work under copyright law and is therefore left without a significant remedy in order to at least mitigate the negative impact of the distribution of the revenge porn. From this point of view, the authorship as fixation doctrine then not only has problems from the point of view of just copyright law and its putative goal of acknowledging creative input. It also has broader social problems, as was raised with the case of Erin Andrews and in the case of revenge porn. It can in fact have a distinctly gender negative dynamic where you basically get the fixer, oftentimes male, using copyright interests as a way of preventing the person who is in front of the camera, oftentimes female, from enforcing rights to take down unwanted footage from the online environment. The gender implications go even further when one thinks about the authorship as fixation doctrine. Consider the general gender dynamics in terms of who appears in front of the camera versus behind the camera. To take some recent data from the Center for the Study of Women in TV and Film, in 2015, just 9% of all directors for Hollywood movies were women. 19% of all major behind-the-scenes positions, including directors, writers, producers, executive producers, editors, and cinematographers, were women. And yet, although there's still a gender disparity in terms of who performs in front of the camera, those numbers are far more close to equal in terms of gender basis. In other words, in our gendered world, the vast majority of fixers of commercially viable product are men. Women tend to appear in front of the camera rather than behind the camera for a variety of reasons. And in a regime that allocates rights to those behind the camera rather than those in front of the camera, you effectively get, unwittingly or not, massive gender bias because the power of representations of women generally get held in the hands of men, as the case may be in the case of Erin Andrews and the revenge porn we were talking about. Similarly, if you look at authorship registration records or registration records in front of the Copyright Office, you see a similar gender dynamic. Robert Bernays and Doten Ollier found recently a first major study of gender and copyright registrations before the Copyright Office. And they found that 80% of the listed authors of motion pictures that are registered with the U.S. Copyright Office between 1978 and 2012 were in fact men. And the disparity in terms of gender and authorship is similarly grave in other areas and subject matters. Generally, women constitute only 1/3 of the registered authors in materials that are found before the United States Copyright Office. As a result, there is significant gender implication to a regime that vests the authorial rights or copyrights effectively in those who fixate works as opposed to others who provide creative contributions, including creative contributions in front of the camera. Consider this also has socioeconomic and race implications. K.J. Green, a professor of law, has long studied the music industry and the history of exploitation of African American folk artists. He cites the quote, oral predicate of traditional black culture, as effectively creating a massive disadvantage for African American artists under copyright laws. In short, who owned, if you wonder, who owned the tools of creation in the past? Well, it was really the tools of fixation that were important. It was the people who owned the recording studio, who owned the equipment, the film equipment, the lighting, all of that, that effectively were the fixers of works. They are the ones who ended up with copyright interests over the performers, oftentimes African American, who were composing songs, writing songs that were never previously fixed by them in a tangible medium. As a result, the rights were granted to those who were wealthier and those who were whiter. And there are therefore significant racial and socioeconomic implications to this authorship as fixation regime, particularly in a world where, in the past especially, the equipment to fixate works into a tangible medium, be it a recording studio or fancy film equipment, were quite expensive and typically only in the hands of those with socioeconomic muscle. Turning our attention back to the issue of authorship as fixation, the doctrine doesn't merely hurt those in front of the camera who provide creative contributions. It can also hurt those behind the camera who, for whatever reason, don't end up clicking the camera. Our monkey selfie provides an excellent illustration of this point. As you recall, David Slater went to the jungles of Indonesia and spent a great deal of time with the crested macaques living on the Indonesian island of Sulawesi. And through his efforts, managed to get a series of very human-like expressions captured by the macaques in a series of selfies, including the one I showed you earlier. A controversy, of course, ensued, where Slater himself was sued by the People for the Ethical Treatment of Animals, standing in place for Naruto, the animal who took the selfie, claiming that the animal should have a copyright in the photograph and not Slater. The basis of their argument was the authorship as fixation doctrine, which, as I mentioned, is the law of the land in the Ninth Circuit and throughout the rest of the country is at least the default presumption. In other words, in a strange way, they had a perfectly plausible argument that Naruto and not Slater should be the copyright owner. And they would have won if only Naruto was human. As it turned out, the district court rejected Naruto's claim because it held that you cannot be an author unless you are a human being, and that the Copyright Act does not allow animals to become copyright holders. The Copyright Office issued its own opinion on this matter and actually has amended its Compendium of Copyright Practices to state, in fact, that you cannot be an animal owner of a copyright. In fact, authorship presumes humanity. Case came up before the Ninth Circuit, oral arguments were held, but before a decision was delivered, the case was settled. So we'll never know exactly how the Ninth Circuit would have ruled on this issue. But consider the consequences of this holding in combination with the authorship as fixation doctrine. We ask the question, who owns the copyright to this image? Well, on one hand, we're told it cannot be the monkey because the monkey is not human. On the other hand, the authorship as fixation doctrine tells us it cannot be Mr. Slater. Why? Because despite all of his creative efforts in setting up the shot, in doing the cameras, the angles, the lighting, in teaching the monkeys to pose, he didn't hit the click button. And therefore, he can't be the owner either. In other words, we are left with a situation that this work is a work without a copyright holder. In other words, it's arguably in the public domain. Consider the irony of that situation. If I'm walking around with my cell phone accidentally on the camera app and I accidentally hit the push button on my camera shutter, I own a copyright in that terrible, terrible photograph, despite the fact that it took almost no creative effort by me whatsoever. That photograph has a copyright to reward the creativity I put in it. And yet, this photo of the monkey has no copyright, despite the intensive labor as well as creative efforts that went into its creation. This, of course, sets up the question of how we got to such a strange state of affairs, that in fact copyright ownership does not seem to reflect creative labor. And for that, we go back to the sort of theoretical origins of the authorship as fixation doctrine. And that goes to a case called Cerrone. Many years ago, the Supreme Court faced a case that it needed to adjudicate for the first time ever whether photographs themselves could be subject to copyright protection. It seems like an unusual question now, but this was at the advent of photographic technology. Some people argued photography was merely capturing reality. Therefore, it was a technology, that it was not an art. Others argued that although there may be technical aspects to photography, and although it captured a version of reality, that was only a version of reality filtered through the authorial vision of the photographer, and that therefore photography should be entitled to copyright protection because there were myriad choices made in the creation of a photograph: setting, makeup, camera angles, lighting, all of which led to creative input in the final product. Well, the Supreme Court was asked to adjudicate the issue, and in 1896 they did. So the Supreme Court was called upon to decide this issue, and in 1884, in a case entitled Burrough-Giles Lithographic Company v. Cerrone, they did. Cerrone was Napoleon Cerrone, the owner of a photographic studio in New York. He was reputed to be the finest portrait artist of his time. And he had had a very famous man come into his studio to take his photo. That individual was named Oscar Wilde. Oscar Wilde was one of the first celebrities, international celebrities of the modern age. And as part of his publicity tour of the United States, he wanted an image of him captured that would basically tout his celebrity, that would capture his image and expand his popularity. So he sat in, not surprisingly, with the famous portrait artist, Napoleon Cerrone. He went to his studio and, in fact, had a famous photograph taken. That photograph, which you will see in the PowerPoint slides attached to this video, shows Mr. Wilde in a perfect position of repose. Oscar Wilde, a self-proclaimed aesthete, had added numerous creative elements to this photograph, as you can see. He has his trademark look with his head resting on his hand. And he is draped in numerous exotic fashions. There are also a number of other elements, creative choices in this photograph that one can see, including the focus, the distance from the subject, the centering, all of which were also inputs in taking the image. And Cerrone and his assistants had also helped in providing creative input, as mentioned, through the angles, the scenery, the setting, and the framing of this image. All of these factors resulted in the Supreme Court ultimately finding that in this case, photography was in fact an art form subject to copyright protection. The Supreme Court then vested copyright interest in Cerrone. This, seemingly, is a triumph of authorship as fixation. After all, Cerrone was the photographer. He received the copyright. And so it would seem that it's the person behind the camera that receives the copyright. But consider for a moment the other people who could have had a copyright interest here. Oscar Wilde, as we mentioned, was very much a man who had created his image. His image was an act of authorship, as dictated by his particular expression and his general mood and setting, as well as his choices with respect to his clothing and the overall look and image he wanted to present. He certainly could have had some colorable claim to a creative contribution that would vest with a copyright interest. And on top of that, Cerrone's assistants, including the makeup artist, as well as the people who set up the stage, could have had an interest. Yet the court didn't consider any of those other individuals as potential copyright owners. That would seem to mean that the court rejected their copyright claim. But in fact, that would be incorrect. Although for over 100 years, people have assumed that Cerrone, the case, tells us that Cerrone, the photographer, is a copyright holder in this kind of factual scenario, the case actually says no such thing. One long-forgotten part of the case was the fact that Cerrone and Oscar Wilde had a contract in place. The contract, mentioned in passing in the reported decision in the Burrough-Giles v. Cerrone case, states very clearly that there was no dispute as to who owned copyright ownership in the case because Oscar Wilde had by contract given any copyright interest to Cerrone. So in other words, the Cerrone case from 1884 never decided who the author should be. All it decided was that there should be an author and that there is a copyright in a photograph. In that particular instance, the issue of who the author was simple. It was Cerrone because the contract had dictated that it be Cerrone. But that wasn't the necessary result of a factually similar scenario where no such contract was put in place. In other words, Cerrone did not dictate that authorship as fixation should be the reigning authorship doctrine of the United States, although that is the popular assumption that has been made from Cerrone and has gathered through the years, culminating in the ultimate en banc decision of Garcia v. Google. So although we've gone through more than 2 centuries of copyright jurisprudence, we still haven't fully grappled with the issue of authorship, which is unusual since authorship plays such a key role in copyright law and dictates the vesting of basic copyright protections. The Garcia v. Google case is emblematic of the types of fundamental questions, both about the nature of authorship as well as the recognition of creative contributions by those who don't fix works in a tangible medium, that courts will have no choice but to have to address in coming years with the advent of technologies that enable amateur content to be commercially viable for the first time. As such, Garcia represents only the opening salvo in the coming battles over authorship. But it was a dramatic broadside. In a watershed moment, the Ninth Circuit found that authorship as fixation is the law of the land. Although the Supreme Court's previous guidance on the issue, CCNV v. Reed, suggested there was a default position of authorship as fixation, that guidance suggested that that default position was rebuttable and not absolute, that it was merely a general rule. In other words, the Supreme Court had previously left room for instances where performers and other non-fixers could be deemed authors because of their creative contributions. But the en banc decision in Garcia v. Google rejected that room and said that there would be an absolute rule because the plaintiff in that case could not have a copyright interest because, quote, she played no role in fixing the claimed work. As a result, the court seemed to announce a bright line rule now that a, quote, performer must personally record his creative expression in order to retain any copyright interest. And, unlike the CCNV case, the issue of authorship as fixation was central to the resolution of Garcia. So, we have a scenario where authorship as fixation now is threatening to become the unmalleable standard for the vesting of copyright interests. But, as our examination of both Garcia and surrounding cases suggests, when one looks at cases involving animal selfies, sex tapes, peeping toms, surveillance footage, and even ordinary photography, there are good reasons why we should not accept authorship as fixation as a general rule or even a strict rule without further scrutiny. Courts have badly mangled copyright principles in the process of hewing to the authorship as fixation orthodoxy, a result that's not surprising given that the doctrine itself is both legally tenuous and intellectually incoherent. A strict authorship as fixation rule, in fact, betrays copyright's role in recognizing and rewarding creativity, and in fact, it denies copyright interests to the very individuals who have provided significant, if not in some cases, the most important original contributions to works that are within copyright subject matter. Recognizing the interests of the performers in front of the camera and the creative contributions of even those behind the camera who may have nothing to do with a work's fixation may well represent an ideal that is fraught with some landmines. The liberalization of authorship may result in the balkanization of rights in a way that would be unwieldy, that would undermine the alienability of intangible rights to creative content, and might impact the market for licensing of works. It may also have profound First Amendment implications. Our juridical conception of authorship, which typically vests rights in a single mastermind behind the camera, may constitute a convenient and valuable way of avoiding such troubles, such as the balkanization of rights and the First Amendment consequences. But it's also important to remember that the recognition of performer copyrights is not at all foreclosed by the Copyright Act. And, as illustrated by this SALE, there may be good reasons to consider the concept, particularly in certain circumstances where authorship as fixation leads to both troubling results within the four corners of copyright law, as well as troubling results for other social considerations, including gender equity, racial and socioeconomic issues, as well as public policy. As a result, authorship as fixation is not a matter that should be foreclosed and decided by judicial fiat. A broader debate over the issue is needed before authorship as fixation becomes the law of the land.